One.
Okay, welcome to December 21st zoning hearing board meeting. We're going to continue with the appeal number 21-1906, the Gabriel Deck and Alexandria Kovic Deck. You got all that. Anyway, I'm sorry, there's a volume issue. I'm on.
There's feedback.
Is there feedback? Oh, yeah, there is. Who's too loud? Any better? All right. All right. Want to welcome everybody here right before Christmas. Thank you again. And we got a little bit of a continuation for tonight. I understand there's a couple exhibits that need to be introduced again or introduced. So we will start with, I guess, with Fenningham, Mr. Fenningham, on your introduction of those exhibits. All right. I don't hear your mic.
Now,
You hear it?
Yep.
Your mind's just too loud.
all right, again, John Fenningham for opposition party, the McDonald's. I've circulated to all council and to Jim Majewski two additional exhibits that are responsive to the concluding testimony of both Vince Fioravanti and Justin Giannotti on November 30. I'm going to take them in reverse order with just a few questions to Mr. Fioravanti, but Exhibit VF8 is a letter on the masthead of Kavanaugh Surveying Services of Doylestown, PA, dated December 15, addressed to Mr. Fioravanti under seal of Patrick A. Kavanaugh, professional registered surveyor in the Commonwealth. May I question Mr.
Sure,
Fioravanti?
go ahead.
Vince, would you look at that and would you advise the panel that this letter is in response to the question about equipment, survey equipment calibration and tolerance of survey results?
Yes, I requested this letter, as we discussed at our last hearing, to certify the accuracy and the methods of surveying that were employed at the site under my direction. As the letter states, the elevations were obtained on FEMA NAVD datum of 88 using a GPS Trimble R12 using the Boyd network, which is a local survey company. It also mentions the tolerance and the accuracy of the system at 0.1 foot vertically, which I believe is the same as the applicant.
Unless there's a cross-exam on that, I'd ask for that to be admitted into the record. Exhibit VF8.
Vince, thank you for that. But no one has produced the plan at this.
Is your mic on? Or it just needs to be closer?
I'm sorry. Mr. Fioravanti, as I said, Exhibit 8 that you and Mr. Fenningham just referenced does make reference to a survey plan, but that survey plan has not been produced as part of this proceeding, right?
Well, there's not a separate plan. One of my exhibits has the results of that survey shown on the exhibit. It's an exhibit we already testified about. It shows the elevations that we surveyed compared to the elevations that were on the applicant's plan. So there is an exhibit of mine that has the results of that survey that's already been testified to.
We don't have a plan.
We do. It's one of the exhibits we already testified to. Remember when we were saying we were 2/10 lower? And then I started to say that this inlet was 2/10 lower and that one's, and we have our elevations in a different color. So we do have that exhibit. It is in the documents that we discussed
It's your plan based on the results of that.
of that survey.
Okay.
But there's no way without the plan that we can verify the accuracy of the points that Mr. Kavanaugh's plan represents, though, right?
Oh, it's no different than us being able to verify the accuracy of the exhibits that the applicant has produced. You know, we have field data,
If we produce the plan.
They have a plan.
right? Well, the plan that I produced is the plan that I produced with the surveyor's results.
Okay,
and
so there's no
sealed
plan.
Under my seal, so it's the same thing.
Okay, I'm not going to belabor.
Okay. All right, that exhibit?
Yep.
Adam,
No objection with that subject matter.
that exhibit will be accepted as,
I think that one, is that one VF8?
VF8,
VF8.
Vince, Vince.
Yeah, VF8.
And I just skipped because that one seemed to be simpler to address.
Mhm.
Vince, you are a certified land surveyor in the Commonwealth, correct? Okay. The other matter that was brought up on November 30, let me ask you, did you assess the rebuttal testimony offered on that date by Justin Giannotti on his assumption that your survey was not originating from a fixed field point? Did you review that assumption that he made?
Yes.
And do you agree with that?
No.
You surveyed from a fixed point at the site.
Yes, we discussed it briefly when we went through our exhibits. And my conclusion was that our results were roughly 2/10 lower than the applicant's field work. And we discussed the implications of that. Then when Justin was discussing the difference in the elevations, he may mention that we surveyed fixed objects to compare. And if we're surveying something that's 2 foot wide by 4 foot long, top of an inlet grate, it could be not level. So we could have been on one side and they were on another side. But we did actually hit their benchmark. I think Justin even mentioned that they do have a nail that's a benchmark out there. And I saw it on the plans and I made sure our guys hit it. And that's essentially sitting the rod on the head of a pin, basically, so that you can get an accurate comparison for that. So on our exhibits, if you were to look, there is one benchmark called this, identified as a mag nail, and it's on one of the exhibits we already discussed. And our elevations are shown there, and I think we were minus 0.17 compared to that one. And then some of the inlets were minus 0.22, on an average about minus 0.2 lower. But we did hit the benchmark, so that's an accurate representation and an accurate comparison.
All right.
Does that provide assurance that your survey exhibit incorporating the Kavanaugh survey field work is true and accurate?
Yes, what it does show is that our elevations were essentially a rough average of 0.2 lower than theirs based on the exact same spot.
And you've said that, yes.
Did you also prepare a further exhibit based on the exchange of testimony on November 30 that I've marked as exhibit VF7?
Yes.
And could you explain that exhibit to the board? And I'll ask you, is this exhibit under your seal?
Yes. I'm going to go to the board mounted exhibit so I can point to it. When we were listening to the testimony when Justin was reviewing our exhibits, some of the things that he said, I just want to clarify so there's no confusion. There was a point when we looked at this exhibit, as you're familiar with. This is the same exhibit as one that I had previously submitted. I did add a couple things to it. Justin had said that, topography is not a consistent surface elevation. When you look at any piece of ground, the slopes and the contours and the terrain, they vary. They smoothly vary from one to the other. You have some areas that are consistent. Then you have, bumps and holes and streams cut through, and that's what the contours represent. When you look at the contours, even if I look at the big exhibit here, you can see the 90 contour, or I'm sorry, this is the 88 contour and the 89. And then what I was saying when I was testifying about this is that it's not consistent. Where the contours are closer together, it's steeper, and where they're farther apart, it's less steep. That's how the 3D model works. So I wasn't saying they were consistent. I think when Justin was saying that they're not consistent in here either, and that could be true. But the way you interpret a topographic model, it's why I added some additional detail to this. You go out in the field, and I don't know if you can see it at that distance, but there's spot elevations. We talked about spot elevations. It's almost like going to a surveying class. So the surveyor is out in the field and he has a rod with a reflector or a satellite dish receiver, and he gets elevations at different spots on the ground. And if there's an area that's relatively constant in slope, if there's a top of the hill and the bottom of the hill, you get some shots at the top of the hill and some shots at the bottom of the hill, and that could be 20 feet down. And the computer then calculates contour elevations in that area. And if it's a constant slope, those contours show the approximate grade between those 2 points. And that's how you interpret this 3D model. And it's relatively accurate. If there's a spot between the two spot elevations, that's very low or very high or atop a bank or something that's unusual, then the surveyor is supposed to get on there and take an elevation of it. So if I were to look at this, for example, the spot of elevation at the top is 88.8. And I'm using all their data. I'm not even talking about the 0.2 difference. 88.8. Over here is 89.6. You can see this orange line between the two. So the computer, we used to do it manually, but the computer then calculates if that's 88.8 and that's 89.6, then 89 is going to be close to this 88.8. It's going to be right here. And same thing in this direction. There's 89.6 and there's 88.8. So between the two of them, if you take a constant slope between the two of them, then 89 is right here. So that's repeated over and over again. And the computer generates this contour and generates this one. And between the two of them, the elevations are consistently changing. So if I look at this comb, I'll call it, that I produced here, it's 88 here, it's 89 way over here. So in the absence of any other information in between, it's a constant grade. That's how the computer's modeling it, because that's what the surface of the ground is here. It's a constant grade between 88 and 89, and you divide that into 10, and this is the elevation between those 2 points. Now, if it was steeper here and flatter there, there should be an elevation mark here. I think the surveyor should have put a spot elevation here. If it went up 10% here and then was dead flat all the way to here, there would be a bank there. But in the absence of a spot elevation, that is the elevation that this computer model says is on this ground. So when I look again, now I'm not saying that things are all consistent. I'm saying they're not consistent. That's why these slopes vary. That's why the length of these combs vary, because it's not consistent. So the elevations tell the whole story. If I look here, and I think this is the crux of the entire case really, is this 88.2 elevation. Remember, the elevation of the floodplain was taken as 88 flat all the way across, and we established that that's not really true. That it may be 88 at a certain spot, but at the edge of the house was 42 feet away, that the applicant said it was 88.2. I think it's, when I read the profile, I say it's 88.3, and I think it's over here. And I think 88.2 is over here, 0.2. Now, the applicant said that the 88.2 spot elevation, you can see how close it is to the 88 contour up here. It's literally 5 feet away from it, right? So they took that 5 feet and they offset this line, 2.5 feet, 2.5 feet, and came all the way down here, 50 feet away, and said, if it's 88.2 here, 5 feet away, it's 88.2 here, 5 feet away. That's not true. If it's 88.2 here and there's no spot elevation here, we have no idea what it is here. All we know is between here and here is 1 foot. And here's the gradual increase in elevation between these 2 points that we have. And if you take that average, 88.2 is here. And again, I think it's 88.3 when I read the thing. The other thing that you can see, and you can see these red dots, I colored them red. If I were to take this fact here, that's 2.5 feet for each 10th, that's about a 4% grade. The grade here is 1.5%, like between here and here, right? So if I were to say, accept that assumption, 88.2, 50 feet over here is right here. If I were to continue with that slope, each one of these little circles is 2.5 feet. So I would say 88.1, 88.2 would be right here, the second circle at the end of it. If I were to continue in that, with that slope, here's 88.3, 4, 5, all the way up to 89. And I'm only in the middle of the house. 88, 89 is way over here. So you can see how different that is. 89 would be here, when in reality, it's way over there. So it's not that steep. And the way you interpret this 3D model is that 88 is here, 89 is way over there. And so this is actually what, if I were to take a computer-generated elevation from this model, 88.2 would be here, unless I had some other spot elevation here to tell me that. So we can't take a spot elevation 50 or 60 feet away and say that's the elevation over here, and it's 2 feet away from the house. And again, that's the water surface elevation. So not to make a mountain out of an anthill, but I believe that it's here.
But did you have a spot elevation there in that area?
There's no spot elevations at all between here.
Okay.
So then what you would do is you use the contours that the computer calculated,
And
and then it's an even grade between them.
all right.
So that's the end of that. Now, if I can continue, should I continue into the stormwater system? Well, I'm at it. Okay. So there was another implication, I think, that we didn't, well, we probably did discuss it, but might as well get everything out while I'm up here. We talked about the rain garden and the stormwater systems. Again, I believe it's in the floodplain and it's 88.2 or 3 in this area. I'm going to flip to another exhibit. Oh. Let's see. I don't recall what exhibit this was, but we had put this in before. So I've added a couple extra notes to it, but just as I was looking at it. So remember that 88.2 elevation again. I think again that's the crux of the entire case, the way I see it. Let's assume for the moment that the 2/10 difference, forget about that elevation. 100-year storm, 88.2. There's a lake here, and it's 88.2. Now we take a look at this stormwater system, which I'm going to maintain doesn't work for peak rate control. I heard testimony or read it that there was infiltration, in this rain garden area. So, it would control some volume in a 2-year storm. But in the floodplain, I don't believe that this can handle rate control. I think it'll increase, not only redirect water because the floodplain is going to hit the house, but I don't think it's going to have any chance of controlling peak flows. So I think whatever flow is coming past here, and I thought I heard 700 cubic feet per second, in the FEMA study, it's going to get a little bit worse if this is built. So I'm not saying whether, how measurable things are going to be, but it's going to make a bad situation worse. I think the peak flows are going to go up and the water is going to be redirected. And here's my reasoning. The rain garden is going to discharge into an inlet here, an existing inlet that comes to the stream. The invert of that inlet is elevation 84.18. That's on the applicant's datum. That's their data. 84.18. This piping system goes into the stream where the water's elevation is 82. And this, 88, I'm sorry, 88.2. So the water elevation is 88.2. The bottom of this pipe is 84.2. The pipe's underwater. So if I have this inlet, the top of the grate is 88.3, right? The bottom of this thing is 85, 84, 84, 85. It's connected to the stream. Water's going to flow up into it. So you're trying to discharge your rain garden into a pipe, an inlet that's 4 foot deep. It's completely full of water already.
Are you saying that the stream is going to backflow into the pipe?
Yes, absolutely. So the stream backflows into this pipe. It's completely full of water. The inlet that you're tying into, you go down 1 inch and the water's sitting there already. So it already has 4 feet of water in it. Now your rain garden's filling with water. It can't push that water into this pipe. Matter of fact, if this elevation here is 89, where the rain garden is, if you dig the rain garden down a foot, now you're at 88. Now the water's coming back into the rain garden. The rain garden's going to be filling full of water. It's also going to be trapping water from uphill, and it's going to be getting water from the roof. So the rain garden's going to be full of water already. It can't get out because this pipe's full of water. It's just going to overflow. Water's going to go around the house, and it's going to be backfilling in the side of the house and flowing around. So I look at the 50-year storm, and that elevation is almost the same as the 100-year storm. So maybe this pipe, instead of having 4 feet of water in it, it's going to have 3.5 feet of water in it. Same situation. And actually, the 10-year storm, if you look at the profile, I don't want to flip another exhibit, but the 100 and the 50 and the 10-year storm are on there. They're only about a foot difference. So, completely full, maybe overflowing. If you took our 2/10, it's coming out of the top of that inlet. But that system's full of water. This rain garden's going to be full of water, might even back charge, from the flood. And I think the whole situation just will not work for the peak flows and will make a bad situation worse.
Vince, that pipe is in right now, right?
Yes.
Right. So is there any, without the house being there or anything, does that situation happen now? Where the
Yes. Well, I mean, if this
stream
pipe is
goes back
definitely in, and if we had a 100-year storm, this whole pipe would be full of water up to the top of this grate.
Is that a fact? So we would see it come out?
Yeah, absolutely.
In the street?
And during that kind of situation, it's hard to get more water into it.
And that hasn't happened.
It's kind of like a situation you see at the shore,
All right.
you know, when there's high tide at the shore and
Yeah,
the
I
water
got
comes
it.
out of the
Yeah.
inlets and the intersections, like one of those situations.
Just to be clear, we didn't hear testimony that that happens on a regular rainfall. It comes.
No, that's during the 100-year storm
100-year
event. Yeah.
Just to be sure,
Or the 50, you know,
or 50.
but that's, you know, the peak flows, when they always look at the requirements, it's always, you know, the design standard is the 100-year storm. And during that 100-year storm, it's not going to work.
We've had some pretty big storms recently.
We
I
did.
was just, they're not 100-year. Yeah, okay. All right, fair enough. All right, well, that's a lot of a presentation there.
I have one question for
Oh,
Vince.
certainly.
And just a couple questions for Justin.
Okay.
Vince, just one thing which
I know.
I know it's accurate and you've said before, but just confirm, your VF8, the letter from
Yes.
Pat Kavanaugh.
Mhm.
We're confirming, and this confirms that when you did, or Pat did whatever he did, he never accessed the site,
True.
right? He identified in the first sentence, he identified fixed locations at or near the intersection, but
Yes.
never on the
Yes.
site.
Absolutely.
Okay. No other questions for Vince, but I have some redirect based on Vince's testimony on his VF7.
Okay,
And rather than go through Vince and then Justin, I think it's easier to just deal with it that way.
all right.
Justin, here. You've now seen VF7 and VF8. You've heard me ask Vince several questions about certain presumptions that Pat Kavanaugh used when he prepared his survey, which we haven't seen, but which Vince incorporated into his testimony, right? And he confirmed that whatever Pat Kavanaugh did was not done on site, as compared to your survey, which was done on site. Then heard Vince offer his presumptions and conclusions on VF7. Rather than me asking individual questions, why don't you take them one at a time and comment on both the Kavanaugh survey plan and certain of the testimony Vince had.
Sure. Object to the form. Ed uses the terms assumptions and presumptions. None of that is in the record tonight. This is Vince's expert testimony, nor is Kavanaugh making any assumptions. His letter just declares the calibration and the tolerance responses.
They seem like assumptions to me.
Kavanaugh did make assumptions. Vince made certain.
Sure.
I understand, John.
Okay.
Yeah.
Well, you just said Kavanaugh made assumptions. That's what I was clarifying. All right.
Starting with VF7, at the last hearing, we did ask for a plan itself signed and sealed by Pat Kavanaugh, which correlated the points that we located in the field with the points that they checked into in the field. And the reason that we asked for that was that we wanted to have a comparison that they were shooting the exact same location to confirm the discrepancy, which was 0.2 or 0.17, 0.22, as Mr. Fioravanti said earlier tonight. We have not seen that plan. We have not seen it. We see a signed sealed letter that says that a survey crew at your discretion surveyed various locations of fixed structures. We do not see a plan which shows those points in detail that we can compare to. We also asked for a point file, which is a survey, the raw data file from the survey. The reason we asked for that is because we could have taken that file, inserted it into our survey, and in AutoCAD compared the points. We did not see that file either. Mr. Fioravanti alluded to previous exhibits which showed points being 0.17 or 0.22 less than ours. We did not see that exhibit either. They would have seen our points, our benchmark, and the corresponding differences between the two. All we see here is a letter certifying that a survey crew was at or near the intersection of Woodland Drive, not on our site. And obviously the survey was based on datum 88 and a tolerance of 0.1 foot vertically, which is standard for GPS and what we also used on our site. So want to make that distinction. We appreciate the letter, obviously certifying that a survey was done and that they used a certain type of equipment, but without the plan that's signed and sealed, even Mr. Fioravanti tonight said multiple times, we believe, we think, we did not access the site. So respectfully, I mean, it's really just hearsay at this point. I haven't seen a plan that shows the discrepancy between our 2 points that we can back into and have a discussion about without that signed seal plan from Mr. Kavanaugh, not Mr. Fioravanti, because he was not the surveyor record.
Is this closing argument or legal counsel?
No, I'm just going, I'm walking through. And then the last point on VF7, Mr. Fioravanti laid out tonight, obviously, that the difference between the contours is not evenly spaced, which supports my previous argument last time, which I agree with. What one point came up multiple times, Mr. Fioravanti said that, without additional spot shots, without additional field data, what's shown on the plan is not all the survey data that we picked up from the field. So plans get very cluttered if you start showing all the field points. So we pick and choose a number of spot shots, which we show on the plan. Our raw data file, our point file, has many more shots. The surveyor picks up various locations, every tree that you see there. Everything that's on that plan is based on a field shot, which has vertical data associated with it. We just don't show that all on the plan, but our 3D model does take that into account. So between the spot shots shown on the plan, there is additional field data, which we did take into account. That's why we say that we certify this survey that says that it's accurate. Mr. Fioravanti wasn't on the site to confirm the locations as we show them. We could provide the field data to them, but I mean, it's signed sealed by our surveyor that it's accurate. So when we say it's 88.2 or 88.2, we're comfortable, and we're signing and sealing that with certainty. And
Is this one answer to a question, or is this just summing up the entire case?
No,
I don't know what
it's
to
a
say.
question.
Oh, yeah. He's going on and on and on and
Give a
on.
chance to say,
One more.
And to balance it,
Vince
Vince had went
Vince
on
testified.
at
He
length.
did.
come on, give him a
And
chance.
so if we're going to do it one way, we got to do it both ways.
Vince testified tonight, Justin, that he thought the stormwater design for the rain garden was inadequate. At the last hearing, I think a board member inquired as to what design standard you designed that rain garden to. And I think you were uncertain about the standard that you designed. Have you, since the last hearing, checked and confirmed what design standard that was that the rain garden was designed? And what is that first? And I'll ask you a follow-up.
sure, the rain garden's designed for the 100-year storm. Our previous application was 50. And during the last meeting or hearing, I incorrectly said it was 50 still, but we redesigned it for 100.
And do you agree with Vince's conclusion that the rain garden would not function in a 100-year storm event?
I do not.
And why not?
The whole crux of the testimony was based on our house being in the floodplain, and then the flood waters going around the house during the 100-year storm, filling up the rain garden. Again, as I just said, that based on our field data being on the site with the surveyor, we're comfortable that we're not in the floodplain. That's why we redesigned the house during the earlier proceedings of this hearing. So the house is not in the floodplain, therefore floodwaters will not be going around the house. That rain garden is designed to hold water during the storms and then discharge it at a slower rate. So that has all been taken into consideration as part of that design.
Thank you.
Two quick questions. Just to
Certainly.
be clear, Justin, what you just said about the site, what's the term you used? The site fix on your survey? What was that expression? No, he said there are additional site points that
Points.
aren't reflected on your
Field
exhibit,
data, yeah, field points.
field points, but they're not in the record, correct? You just said we have other data that we just didn't show on our exhibit, but trust us that we did this. That's accurate, correct?
Everything shown on the plan, every tree, everything that's field located has an elevation assigned to it, which we do not show on the plan because it just gets too cluttered.
Okay.
So there's a density to a survey that you're taking points at a certain grid throughout the site that you don't show every single one of those spot shots.
And would you agree that your survey also was based on fixed points off the passenger's property, outside of the parcel?
Can you rephrase that?
Is the culvert that you referred to within the passenger's property or outside of their parcel lot line?
Which culvert did I refer to?
Whichever one you referred to. You said the one that Vince referred to was variable, and therefore he might not have, you surmised that he might not have had a fixed survey point.
Are you confusing culvert with inlet? Inlet top?
I'm just using your terminology. So take whatever one you said he may not had a fixed point. Where was that fixed point inlet that you were referring to?
Inlet. I should say, I don't understand. I didn't use the word culvert. I said inlet. And you're
Okay.
talking about, so,
I stand corrected. Inlet. Is
So-
that within the bounds of the passenger property or outside the bounds of the passenger's property?
that's in the right of way.
It's in the right of way. Okay. So when, just to be clear, the Kavanaugh and Viravante survey team did not cross into the passenger's actual property. They surrounded the property, doing their survey work with fixed points along the perimeter and consistent with the inlet fixed points that were on the applicant's survey. And tying them, as Vince testified, just saying, tying those fixed points into the FEMA benchmark. What you're hearing about not being on the premises, we didn't trespass, but we still were able to perform a true and accurate survey. So it's a red herring to say we weren't on the site exactly. We didn't need to be on the site.
How come that you can't produce this plan?
Well, actually,
I mean, I trust your
Yeah. Oh, yeah,
judgment,
yeah,
but, I
absolutely.
mean, he does have a point.
well, I'll approach this exhibit because we do have the data shown on one of my plans, and that's what I wanted to show you. This exhibit here, it's one of the exhibits that we offered early on, and we testified when I submitted it that we checked these points out here, and one of them is the project benchmark. It says benchmark Magnail elevation 9286. Right underneath of that says elevation 9269 minus 0.17. And each one of these points that I circled here in pink has been on the exhibit already with my seal, my exhibit with our survey data that Kavanaugh surveyed under my direction. So we did produce the plan showing our data and we testified to it and we pointed it out. I just want to show you here. And even the benchmark we checked into. So the plan has been here and we've been testifying to it. I used their surveyors with their GPS network at my direction. I told them what to locate and it's been on the plan the whole time. And it's 0.2 lower even at the benchmark. So I do have a plan with my seal that was surveyed in the field, shows the exact points that we used. And when I show an inlet, it could be 6 inches one way or another on an inlet, but the mag nail is literally a nail. And the elevation we got on their nail was minus 0.17, lower than that. So I do have an exhibit sealed, my name with the field data on it and with the elevations in comparison. And it's highlighted here, but it's been on there the whole time. It's just the same exhibit that I highlighted.
I apologize, I don't have my summary, but I believe this is exhibit VF3 or 4, the one with the pictures in the bottom left corner. So it's one of the exhibits that was omitted into the record based on Vince's testimony prior to November 30. I don't believe I offered or moved for admission of exhibit VF7, this plan.
We have 7. Okay.
Any objection? Okay. All right, that concludes my questions for Vince.
All right. Good. What do you think? Anyone on this? No. Is there, did we go into closing arguments here or is it?
Yeah.
So initially, when this application was submitted back on February 25th, 2021, the township had concerns about the layout of the plan, the location of the proposed house. I am on, it's green. And the number of variances that were requested. As a result of the township administration voicing concerns, the applicant went back, did revisions of the plans, which helped to reduce the overall scale of variances being requested from 7 variances to 4. During the course of testimony, in order to address additional concerns that the township had, I had asked a series of questions as to whether or not the applicant would be agreeable to certain conditions. Those conditions being that any wetland buffer area be extended to 50 feet with any additional trees being planted as may be recommended by the township, that the wetland buffer area will be restricted on record by the filing of a conservation easement or declaration of restrictions to prevent any further building within that area, that a split rail fence be installed to set off the wetland buffer area, and that all stormwater roof gutters be connected to downspouts directly connected and flowing into the proposed garden. And to assist the board, I drafted a summary of the variances presently requested with those 4 conditions. I'm going to pass out copies to Mr. Benningham and Mr. Murphy.
Thank you, Barb.
And if they have no objections, I'd like to distribute copies to the board.
I have none.
No objection.
As a result of the applicant's agreement for the imposition of those conditions, should this board determine that the requested relief be granted, the township accepts the revised plans as submitted by the applicant. Township has no other independent review or information to assume that the applicant has not accurately depicted the survey. I understand that Mr. Fenningham's client opposes that and has offered expert testimony to, contradict the applicant's engineer's testimony. That I will leave to the board as being a credibility assessment. The township is satisfied that the applicant revised the plans addressing the township's concerns. And should this board determine that the requested relief be granted, we would ask for the imposition of those 4 conditions on record, with the understanding that any declarations of restrictions be recorded before a building permit can be issued. Other than that, I don't believe the township has any other opposition to the application.
Thank you, Barbara.
Barb, did you mark this? And do you want to mark it with township?
We can
1?
mark it, yeah.
Township 1?
Yes, I don't think the township submitted any other exhibits.
It'd just be easier for reference. All right, so I'll mark this as township 1.
And I, just so the board understands, I did this strictly because of the number of variances and the number of conditions, so that it's clear what the township was asking for.
Are you concluded?
That's it.
Okay. All right. Next, Mr. Benningham.
Board members, thank you. And thanks for your patience and your attention during these varied hearings. Notwithstanding the township's position as stated in the Township 1, my clients don't believe those conditions will mitigate or ameliorate the conditions that, the site conditions which they oppose. I note that neither the Decks, Mr. and Mrs. Deck, or the Bassingers testified that in support of this application was only the testimony of Justin Giannotti. And I want to go over a couple points in regard to my client's opposition, and I'll try to do that very rapidly. On August 31, I presented Scott McDonald and his direct testimony. He was cross-examined and he was asked questions by Township Council and also by some of the board members. My client's opposition was seemingly challenged, and I asked why. The zoning ordinance provisions at issue, per the revised request for relief, exist to protect the natural resources and also to protect my client's property and downstream properties. It's clear in that sense. Also on August 31, it was suggested during cross-examination and questions to Scott McDonald that my client opposed this application in an effort to deflate the value of the Bassingers flag lot. And he was asked whether insinuating that had he then made an offer to purchase the property at a deflated value. And of course, he testified that he did not make any offer, and he was simply of a mind and a view that this property should not be developed in the way it was proposed. That in his view, he thought it should be kept as open space for preservation of the natural resources. And we went back and forth a bit on that. But if he was not correct in that, you would have heard from the passengers. So his testimony in that regard is indisputable and not rebutted. And I just want to make that point because we spent some time on that.
We did.
Okay. I would say that the value of the flag lot and the flagpole parcel is the point of that is what I argue to you is behind the aggressive request for zoning relief in this case is the desire to deal with the fact that is note 7 bracket 2 of the exhibit A4 zoning plan, in which the note states, quote, due to extent of natural resources on site, no building envelope exists. So this application is viewed in opposition as either a method to argue a purported de facto taking by the township in enforcing its regulations and ordinance associated with this particular property, or it's intended to ignore the ordinance provisions in terms of protecting the natural resources. And I think that's a stark admission in the Exhibit A4 that there is no building envelope. So that is evidence of the legislative intent behind your zoning ordinance to protect the natural resources, particularly on this property, as explained in the applicant's own Exhibit A4. Those ordinance provisions, rather than my client or any neighbor opposing this, those ordinance provisions preclude development of this property, this particular flag lot, as proposed by the applicant. And it's clear that the intent to maximize either the profitability of the property or its development potential, those goals do not satisfy the elements of a variance as a matter of law. That the point being that those elements don't support an argument of an unnecessary hardship imposed on the applicant. In this case, the applicant as equitable owner and the property owners being the passengers. My clients and each of the neighbors, and let me step back, there is 100% opposition from your residents to this application. There's not a single person that spoke in support of this application. So my clients and those residents granted party status, and those residents that just simply spoke and gave you their points of view during public comment, they're equally entitled to the relief afforded by the zoning ordinance, as well as the relief afforded by the Stormwater Management Act, a state statute, as well as the relief afforded by Pennsylvania appellate case decisions that deal with stormwater runoff onto adjoining properties. I believe at the first hearing that I presented, I addressed the ordinance, the township ordinance, about the wording that said excess runoff onto adjoining properties. I want to point out a case that I sent to all council, including Adam Kowalski. And the measure of determining an upgradient or upstream property owner's liability to a downstream property owner for water runoff is, and I quote, however slight, not excess, not anything beyond, however slight. That measure of legal liability for causing water to run onto an adjoining property owner's property is triggered by, and I'll give you a distinction, bookends. What's referred to as the common enemy rule is rainwater that flows naturally down a hill. That's not what we're talking about here, and I distinguish that. What we're talking about is what the Kowalski case addresses, and prior cases in our Commonwealth, cases 100 years old, that dealt with a property owner artificially altering the site conditions and causing water to be diverted or directed in a certain direction with both volume and velocity as considerations. So essentially what I'm saying is whether this board grants variance relief as requested and whether or not the township issues building permits, the upstream landowner, which could be the decks, could be sued in court under the Kowalski standard, most recently applied and reinforced on November 16 of this year by the Pennsylvania Superior Court in the Morgan versus Milstein case. And I'll send counsel a copy. I meant to bring extra copies, but I didn't tonight. This is what drives this opposition. In addition to all the facts that you heard during these hearings, there's both a zoning law, a state statute, and case law that is clearly, I submit to you, on point in connection with this application and the exact relief requested here. The fact that I argue that the Bassingers and selling the property to the decks as a buildable lot are seeking to maximize the profitability to the highest and best use and seeking to maximize the development potential, which case law says is not grounds for granting a variance relief. It is actually the opposite. So I just want to reiterate that there are two primary issues in this case. Mr. Fioravanti testified on November 30th about the second one, but I just want to refresh your recollection. The first is that the dwelling structure is located in the floodplain. And I say that based on Vince Fioravanti's expertise and his presentations of his exhibits. I understand fully that Mr. Giannotti doesn't agree with that. But at the same token, Mr. Fioravanti doesn't agree with Mr. Giannotti. So is this a battle over experts, as been suggested, or is this a battle to protect natural resources? I submit to you that you should look at the level of natural resources that are impacted by this proposed development, including removal of trees, including ripping out the evergreens and the shrubs along the flagpole area that will allow the water to cascade down the flagpole. Just think about that. Forget the location of the house, but just think about the surrounding site conditions that will be changed and altered. And that artificial change and altering gives rise to that responsibility of the upgradient property owner to not allow water to invade an adjoining property or downstream properties. The second issue is that the development of this property, including the stormwater improvements, will increase peak flows. And that's what Vince Fioravanti was saying November 30, and that's what he said again tonight. And I submit to you that the applicant has not submitted rate flows or velocity flows. You haven't been told how quickly the water will flow. But I submit to you, if you look at the photographs that we presented through Scott McDonald, if you look at the videos, you can visually gauge the velocity of this upstream water flowing down through the creek and over its banks, because the photographs, which I'll identify in some, in particular, I'll give you exhibits to consider. You will see that islands are created within the creek, meaning the water is carving out land. You will see trees, roots are just exposed and the trees look like they're ready to fall. You will see that the creek beds have collapsed in certain areas. And most importantly, on the issue of vegetation, you will clearly see that the vegetation is submerged and overwhelmed by the flowing water coming across from the Bassinger's property to the McDonald's property to the Dodd property and downstream to Silver Lake. I think that evidence before you is indisputable. So it's the surface, it's the location of the house, which is one issue, And the argument of the BFE, the base flood elevation, is it 1/10, 2/10? But remember the testimony that the 1/10, 2/10 is feet. It's an engineering site measurement, but it equates to feet. And if there's a variable tolerance, it can go either way. So you have to decide and be comfortable with this possibility that that base flood elevation is 2 feet from the rear wall or in the middle of the house. And if it's even, if there's a variable tolerance, it's almost to the front wall of the house. It could go the other way, but that would still be within the house. And I'm trying to, let me emphasize, I didn't intend to, but Vince made the point. If in particular, if you've been to the New Jersey resorts, particularly Sea Isle City, for example, and the tide is high and it rains, the water doesn't go anywhere except up, and it floods the intersections in the streets. Here, the testimony before you is this proposed rain garden is at an elevation. It may get confusing, but the point is it's at an elevation that it's supposed to flow into the inlet. I use the word culvert, inlet, and down to the stream. But the water's already going to fill up that inlet, and the rain garden is going to be filled up. And the gutters that the township says are conditions are going to continue to pump water. And what's going to happen? It's an overflow situation. In my submission, I was going to say judgment. It's not my judgment. In my submission, it's indisputable that will happen. One other point, there was serious questions to my client, Mr. McDonald, as to his efforts to mitigate the flooding of his property. And I submit to you that the downstream property owner has no legal affirmative obligation to do that, to mitigate. It is the upgradient property owner that has that legal responsibility. And it was submitted that the McDonald's could plant vegetation. Well, I think Mr. Tritt withdrew that when he saw the videos and saw the photos. In fact, he said, "I feel your pain." It's in the transcript. And he said his property has been there for years. He said, when it rains, it's halfway up his property. So I think he got a better sense, and they say a picture's worth 1,000 words. I'd ask you to look at those photographs and keep in mind the flow of water upstream beyond the passenger's property, but coming down, being altered if this property is developed. I'd ask you to focus on, we called it MAC, the exhibits. MAC 1, 4, 9, 11. So 1, 4, 9, 11, 21. Photograph 21 shows the creek flow carving out the islands in midstream. Sounds like a Kenny Rogers song. And picture 22 shows the creek beds collapsing. And I'd also ask you to look at the picture we marked MAC 28. You'll see the pre-development conditions of this area of your township. I want to relate to the 4 videos that we offered through Mr. McDonald. And Mr. Chairman, you asked that evening, well, how hard was it raining during those videos? And Vince gave you that testimony. It was normal rainfall. It was equivalent to a 2-year storm. And I just asked you to, and very specifically, he said 2.3 inch to 3.2 inches of rainfall in a 24-hour period. So he was very specific in his testimony. But imagine the conditions beyond a 2-year storm. Most recently, we had major storms in the area around Labor Day. So imagine the flow of the showing the videos, and imagine something beyond a 2-year storm. Mr. McDonald testified that the creek can't handle any more water. That's a quote. He also testified that the proposed mitigation improvements, the rain garden, et cetera, are overstated and insufficient. Case law says that the fact that Mr. McDonald and other public speakers are lay witnesses does not reduce or diminish the value or the persuasiveness of their testimony. You can take that testimony into consideration equally with expert testimony in this case. They live the situation. I want to turn to one more point. Are my clients at liberty to take affirmative action like building a natural resource barrier or even a dam on their property line with the Bassinger's property? And I submit to you, they're not. The same case, Kowalski would not allow a property owner to divert water artificially backwards to flood upstream if that's conceivable. But you say, well, how could that happen? Well, think of the Hoover Dam. I mean, you stop the flow of water, you back the water up, and it could be pushed back upgrade by artificial means. So they can't do that. The point is the flow of water artificially altered must be addressed at its source. And I believe that the testimony is the source is above the Bassinger's property. Mr. Fioravanti raised the point with you that your regulations require an environmental study if a property is within 2 miles of the river. And this property is. You don't have an environmental study in your record. So again, I would ask you to consider, as you contemplate allowing this development to go forward, what the Pennsylvania courts have said, that the upgradient property owner cannot artificially alter the flow of water and cause harm downstream. Mr. Fioravanti also testified that the 5,000 small project or 5,000 square foot small project exemption should not be granted in this case. He compared it to a property that's flat, that has no river near it, that has no creek, that isn't in the floodplain, and you consider the exemption in that regard. Here, I understand and was pointed out that you don't grant that exemption, but I think you can take into account and consideration that that exemption shouldn't apply, that this property is in the floodplain. And why do I say that? Because Mr. Majewski, at the March 16 hearing, in your minutes, said to you, the property at issue is within the floodplain and near the wetlands area of this intersection. That's a fact. It's in your own minutes. And so I'm bewildered by the fact that the township has not withdrawn its opposition, but proposed conditions that would allow the natural resources not to be fully protected. As Mr. Fioravanti said, the stormwater management proposals themselves, and I won't go into it for all the reasons, they'll be underwater. They're not going to serve the purpose of protecting my client's property or diminishing the flow downstream. This is the record evidence. And I think it's important to recognize that the crux of the case is that the house is located in the floodplain, or it's so very near the edge of the floodplain, if you accept Justin's analysis, that you have to ask yourself, well, what will be the impact of that? You know, what will happen if the water does flow, if we do have a 10, 20, 50, 100-year storm event? I think you can't ignore that element. And I'd ask you to reflect on the fact that the original application was very, very aggressive in both the size of the proposed dwelling and the location of the building. And it was to be presented to you. And only when the township indicated opposition was it withdrawn. And then that was after I entered the picture and met with Ed and met with Justin informally and told them that my clients were going to oppose this formally. And then we had the revised application. But it's still an aggressive application. The house is still in the floodplain, and it's still impacting the natural resources by all the testimony you heard. Now, I'm going to say something harsh because I am an advocate for the opposition. Justin's testimony has been malleable. It's been changing. It's been ebbing and flowing like the creek does. If you look at the November 30 transcript, at the end of that transcript, he said without hesitation and emphatically that his plan was designed to address the 50-year storm. Now, tonight he says, well, I was mistaken. I really designed it to address the 100-year storm. Just like he said, the graphic plotting was a mistake. It was a boilerplate legend. I won't beat that up. But when he revised the second plan, he still didn't take that note off. And I'd ask you to look at that note carefully. I think you should. It says, hey, if you have any concerns, you better go get a FEMA study done because we're not really sure. And just think of that note 32. In the whole contemplation of this case, I submit to you, based on Vince's testimony and the neighbor's testimony and Scott's testimony, that this is a result-oriented design. It is to bring the BFE just below the building proposed site. It's to deal with the buffer areas. It's to ignore the restrictions and open up the envelope to let something be built there. And I think that is wrong. And I submit that to you. I would end with this point. Mr. Fioravanti prepared various exhibits. We presented them to you. He illustrated I'm going to lose the point again, the site point where he drew on the nail and did his calculations. I would submit to you that we purposely didn't trespass onto the Bassinger's property, but they were able, and he testified that they were able to conduct a true and accurate survey, reduce those results to his exhibits. And I just find lacking in credibility that the counter argument, the rebuttal argument is, well, we don't have a plan, but you also don't have all the plan data that Justin said he has back at his office, but he just didn't put on the plan submission. So he didn't say Mr. Fioravanti's wrong, there aren't site points, there are site points. He just said, I have other data that doesn't show up here. So just think carefully as to what was said in rebuttal. It's just, to me, kind of a result-oriented, don't listen to him, listen to me. And with that, I thank you sincerely.
Thank you very much. Okay,
Real quick.
closer up.
The crux of the case was the first night when we presented through Justin the evidence that everyone here acknowledges is unrefutable, and that is because of the application of the various township ordinances that regulate the various natural resources on the site, there is no building envelope on the site, period, end of question. The opponents suggest that that evidences an intent by the township that sites like that need to be preserved. Well, no. What the law says is that a property owner is entitled to make a reasonable use of their property as it is currently zoned. The site is zoned to be permitted to be developed for a single-family home. Absent relief from the ordinances, we can't do it, pure and simple. Both Barb and John referred to the original plan that contemplated a larger home in a different location on the site. And as a result of what is typically conversation that occurs, and the board certainly understands how the process works, we had input from opponents, we had input from the township. And as a result of that, a revised plan was submitted that dramatically reduced the size of the house, changed its location, and eliminated multiple variances that had been originally requested. That is the nature of the process. I don't think anyone would quarrel with the fact that the size of the home today on the current plan that's in front of this board is consistent, if not smaller, than with other homes in the neighborhood. The scope of the relief that we seek as a result of the reduction in size of that home is, in our view, the minimum relief that we could obtain in order to build a reasonably sized home on the lot. And that's the end of the inquiry. If we do not obtain relief, the site is sterilized. This board has dealt with similar applications in the past, some of which I've been involved in. And Barb is right, and John is correct, that in the event that this board would reject the application and sterilize this lot, there will be a claim against the township for a de facto taking, because effectively that has what would occur here if the board does not grant relief. Pure and simple. So as to the issue of the survey, as I think Barb indicated and John did as well, it's a matter of credibility. I appreciate the fact that some board members have experience in this. You've heard us testify through Justin as to how we did our survey. And I think it's important for the board to remember that unlike the opponents, our survey was done in January of this year. We didn't submit an application for a couple months after that. We did the survey with no preconceived notion of what it would show or how we would lay out a house after we had the results of that survey. No question that if there is ever a result-oriented outcome here, it would have been the opponents having done the survey after they already had expressed their opposition and knew where they wanted to go, and magically their survey differs from ours. Okay? And no one's going to quarrel with the fact that their survey was done many months after they entered the case and expressed their opposition. In terms of what obligation the property owner has, I think it's ironic that the opponent doesn't feel the need to take any care to mitigate any impact that his property has on other downstream property owners. If he did, he probably wouldn't have mowed and manicured his grass to the edge of the creek, which I know some board members previously inquired of. And that is what it is. But I don't think it is, I think it's above reproach that anybody could argue that the revised plan, the revised scope of relief, and all the precautions that we have taken in the design of our plan and the stormwater measures does everything possible to mitigate any adverse effect on downstream property owners. And yes, we are presuming, our plan presumes that our proposed home is not in the floodplain, no question. So we believe that we're entitled to relief. We believe we've made the case that we're entitled to relief. No one has challenged the fact that there is no building envelope here based on the way the ordinance worked today. And we are willing to accept the conditions that the township outlined in Township Exhibit 1 as a condition of any relief that this board may grant. But I think we have made a case that this result cries out to be approved, because absent no one, be it the applicant, the Boussingers, or anybody else, could do anything with this property. And under the ordinance, we're entitled to build a single family home on it because that's the way it's presently zoned. Thanks.
Thank you, Mr. Murphy. No, you're done. You got party status, right? You've already spoken for an hour and a half.
Okay. Just the subtle changes. When this whole process started, my name is Edward Bach. I'm at 598 Kelnish Drive. At the beginning of this process, there's a negative build. It's not that there's not an envelope to build on, it's negative. The front setback is actually further back than the rear setback. So I just want to distinguish that point. The other thing, as a non-expert, I'd like to say is the two engineers are 2/10 apart, right? Each one of them says there's a 1/10 margin of error, which means the middle is the overlap, which would be the likely place where it's to be, which, if I'm not mistaken, that overlap puts the property in the floodplain. So what they're asking for is reasonable accommodation to build this house. And we all understand that. But as members of the community, we want to have that same reasonable accommodation, that properties downstream and that our community is not damaged. So I'd like you to consider that. So I think that it's reasonable with a township that has all these setbacks, and setbacks have purpose, to require them to have a setback off the floodplain, even if where he has it. They're asking for the normal setback, and then they're asking for the 100-foot wetland buffer area. So they're at 120 feet roughly what they're asking. Is it fair to give them 110? Is that reasonable? Have them 10 feet off the floodplain to give us a little bit? Sure. They're entitled to build a property. They're not entitled to build whatever size property they want. They can make the footprint of the house a little bit smaller to grant that little bit of space difference. The other question that I have for you, because you asked me when I brought up the point that the downspout from the house behind it upstream, that water is going to flow right into the rain garden. You asked me if that was in the calculations, which I have no idea. But we never asked them whether that was in their calculations, because that's all additional water that's going to overflow directly into the creek if it's not in their calculations, because that's a substantial amount of water right there as well. So the other question, when the township, and I've been watching these meetings for a while, whenever somebody wants to put something over top of a piece of infrastructure, whether it be a pipe or whatever like that, it's always brought up, if that has to be replaced or fixed, who's going to pick up the cost of that replacement? Well, they want to build a long driveway right over a storm pipe. So if that storm pipe has to be replaced or fixed, or if the township decides to put some kind of grease traps or oil traps at the end of it to prevent road dust and road stuff from getting into the creek, who's going to pick up the cost of removing a driveway and replacing the driveway? Would that fall under the decks, or would that fall under the township? These are some of the questions that in previous cases that you've pushed back on residents for things that I haven't heard being pushed back on this particular project. This project, when people are looking at putting pool decks in and there's going to be water that goes downstream into one property, this is going to affect 100-some properties downstream. This is going to affect the lake, which is more or less serves as a public park for the community. So, I mean, these are the things that I think we can all agree that by eliminating the buffer zone for that water runoff, which the whole point of it is to purify and filter some of the water, by collecting it in a rain garden and then injecting that excess water directly into a storm drain and directly into the creek, that you're likely could be creating dirtier water for the township. I think that's a fair assessment, because you're bypassing the wetlands buffer area, which is serving as a filter. So if this project is going to create dirtier water and higher volumes of water, which is going to cause erosion and other issues and sediment in the lakes, that's not reasonable to accommodate this. There's other things. They can come back with another plan that's a little bit more reasonable to the surrounding properties in the community in general. And I'd also like to point out to you that on their plan, their rain garden was about 30% smaller than what their water calculations were. I've never seen you guys take a plan that was so far off and not question a little bit to find out where that extra space is going to go. So as a resident, I'd like to understand where they're putting that other 30% of that rain garden. What we have is they're trying to put 15 pounds of manure in a 10-pound bag. So the question is, can you make reasonable accommodations for them to do that? Yes, you can. You know how you do it? Make them put 10 pounds of manure in a 10-pound bag.
Thank you, Mr. Bach. And this board has always done the right thing as far as I'm concerned. And we've always considered it the public comment like yours and everybody else's.
No, I
Those
appreciate.
things you mentioned, we have done. So-
Okay, I just haven't heard them, so I don't.
Huh?
As a citizen, I don't know what their plan
Okay.
is for the rain garden, and I don't know whether those numbers are.
All right. Thank you very much. All right, good, bring them on. We have one more person.
I'm not sure if they want to make.
Well, wait, okay, who's there? All right, Nancy, do you like to make a comment?
Yeah, I don't want to be redundant. I don't want to repeat myself.
I appreciate that.
I just stand by my original comments that I'm at the end of Edgewood Road. It is, I am vehemently opposed. And I think that it is destructive for all the reasons that were already mentioned. I'm just restating the obvious, which is my severe opposition to this township granting a variance for these folks.
Okay, thank you, Nancy.
You're welcome.
Nancy Powers. Thank you. I think that's it. Public comment is done. I want to, at this point, it's decision time. Firstly, I want to thank the applicants and you, the opposition. You did a tremendous job, and you should be accommodated for that some way. For your clients, you did a really good job. Just watching it in action has been good. And the public comment, quite frankly, has been tremendous. And this board has always looked at that. And I do say, and I'm sure the board does too, the splitting of hairs, the 2/10, the 1/10, we all got it, the 1 foot, we understand it. And we also understand nothing's perfect. We got that. So there's a lot of things to consider. But again, I appreciate the time you guys spent on this. And I would like the township or the zoning board at this point to introduce a motion. But when whoever introduces the motion, I want to make sure it's very specific. We have the township variances that we have to accommodate, of course, and anything else that, especially my expert guys, would think that we should put in there to be considered, and I think it would be appropriate. I don't want to take any chances of leaving anything out, but I want to be fair to everybody. So at this point, if we can do something like that in a motion and be fairly specific, I'd appreciate that, and I think everybody else would too. So at this point, I'll ask one of the members.
Well, I'd like our solicitor to address some of the case law and the law that was mentioned. We didn't get a copy of this decision. The board members didn't get a copy of this decision, but you said you gave to our solicitor? Oh, it's on. It's on. I'm not speaking close enough. Sorry. I think Kowalski, you said?
Kowalski was one that I did provide copies to all council. The Morgan Milstein case, I have a copy with me. I can give it to Adam tonight. And it's the November 16, 2021 decision of the Pennsylvania Superior Court.
And can you recap it? Have you read that, Adam?
I just pulled it up after council mentioned it, but I haven't. I haven't been
Did you
notified
provide
about
that to our
one.
solicitor
I can,
previously?
not before, I can do it now. It just came out.
The Kowalski decision?
No, the Kowalski I provided to Adam, yes,
Okay.
back in June. And
My view of Kowalski is not applicable at all because it deals with other issues dealing with stormwater, not with the issue that's in front of the board.
it actually dealt with the development of an up-gradient property that caused water to flow onto Kowalski's property. So it's right on point.
And is this a zoning decision or is this, I'm sorry, is this like a civil?
It was a
lawsuit
civil
or something?
lawsuit that raised it.
Superior Court, not Commonwealth Court,
Okay.
not a zoning case.
Okay.
Before I was rudely interrupted, I was going to say,
No,
I'm going
no.
to say the same thing.
no,
Yeah.
it was a case brought for continuing trespass and public and private nuisance. It made law in the Commonwealth of Pennsylvania. It underscored the prior law and made it crystal clear what the upgradient property owner's obligation is if it artificially changes the direction of surface water flow. And it indisputably added the measurement of however slight. And that's what the Morgan case upheld, an injunction granted to the downstream property owner to cause the upstream property owner to be compelled to abate the flow. So that's if you are inclined to grant relief and the property is developed and there's however slight water flow, the decks will be open to litigation to abate whatever harm is caused by surface water flowing onto downstream properties. That's the gist of that case law. And the case law in Pennsylvania says that legal liability exists whether a zoning board grants relief and whether a township issues permits for building, regardless that the property owner's rights are equal to, if not greater, than the upstream property owner who wants to change things and cause change in the direction of surface water. And I think that's an extremely fair summation of those cases. And I'm happy to give Adam
It's
the
always been the case. That's the
it
case
maintains-
today.
No,
That'll
I
be the case
understand.
tomorrow.
No, I understand it's a civil
yesterday.
case, right?
Yeah.
My other question has to do with the de facto taking. Both of you mentioned it. I haven't heard from our solicitor. I disagree with you slightly, Mr. Murphy, about our ruling, yay or nay, is 100% In other words, it's only on the plan submitted, not, perhaps not a different submission. But that being said, I'd like to know more about that. And because I didn't really hear what Mr. Fenningham said about but I heard you mention it. So I'd like to know more about that and where we are on that.
So you can have an executive session with Adam and you can.
But I did want to propose that, yes.
Yeah, I mean, we can, I guess.
I mean, we could
sense
just,
for
we
us
could
to-
step in the back.
Yeah, we can
right?
step. we
I
can
actually
step
have
in
one
Talk
question.
about that.
In the office
Case law.
or briefly.
I actually have one question here for Jim Majewski too. The environmental study that's been mentioned repeatedly, where in the permitting process or planning commission or SALDO review where does that fall process wise in the review?
Okay, actually, this property is not within 2 miles of the Delaware River. The property abuts Silver Creek, which flows through Silver Lake, through the golf course and into the Delaware Canal. The Delaware Canal then goes down south of Bristol before it enters the Delaware River. So technically is not within 2 miles of the Delaware River. So that would not be applicable in this case.
Okay.
Thank you.
Okay, do we want to take an executive session?
You want any questions of council before we take that, or do you want to take it now? Meaning, do you want to hear Ed's rebuttal of the issue with, the case as
Kowalski case?
summarized
Well, the
by,
Kowalski case is done. I asked a question about the de facto taking,
sure.
just separate issue.
Adam should be the one to counsel.
No, that's
I
fine.
agree.
We'll talk about
Okay.
that. Mm-hmm.
Copy
Thank
of
you.
the what? But the Morgan case is also the Kowalski case, affirmed. Okay, right. It's
All right.
progeny of, okay.
Beaver Pool zoning permit for the dam.
Oh, I know. It's funny when they said dam.
Actually, it's not a zoning permit, that's a state.
Okay. We're all back.
First thing, that's like Adam explained what we went into session for, so everybody's clear on that.
Thank you,
If you will.
Mr. Chair. We met in executive session and discussed some of the legal issues related that council brought up and legal issues related to the requested variances.
Okay, I mean, there's been a lot going on here. I would think that the board members would have some kind of things to say before we make the motion. I mean, I've heard some good testimony. Was wondering if anybody wants to chime in on something before we go and make a motion first. I don't know if I'd like to make a motion first and then have a used discussion and then have to do it again. But if we can maybe comment in front of everybody, what we feel like. Anybody have something they want to say first? Pete, can you?
Okay. In reviewing the township's Exhibit 1 proposed conditions, was wondering if the decks would be interested in considering application of even further conditions to the variant, to their request beyond what was proposed by the township. Such as the point about access for maintenance to the culvert, potentially a description pushing back the property boundary a little bit farther to account for a split between the differences regarding base flood elevation. Mhm.
He can't hear you.
Okay,
I can't hear you.
sorry, Ed. I'm sorry. Okay,
Typically, the issues that have been raised tonight about the adequacy or the specifics of a stormwater design or the rain garden or something like that normally would be conditions of approval that would be subject to Jim Majewski's review and the township engineer, which is a normal condition which we would certainly accept. And as to other suggestions, if you want to make them and say subject to review with the township engineer and Mr. Majewski, we're happy to sit down and do that. Yeah. And you should know the sewer easement that's recorded, if we were to build over it, with the driveway, of course, the authority would expect us, unless it's in the easement, to be responsible for if the easement had to be, or the pipe within the easement would have to be replaced. That would probably be on our cost, whoever that would be. The authority would replace the pipe and we'd have to repave the driveway at no cost to
Exactly.
the authority. That's, and
that would be
Tony,
expected.
you know. the way it
Yes,
works. So,
yeah. And that public comment from that person that suggested that, and that has been what we've always done.
Right.
So I kind of thought that was known or obvious.
Right.
James, you wanted to ask something, I believe, or no?
No, I just wanted to make a comment that I found both engineer experts to be really believable. From my seat, this is a difficult decision. These guys are both really close on their findings. I'd like to go on record as saying I'm struck by the fact that nobody came out in support of this, but yet we have 100 people in the township that are against us. That kind of resonates with me. That's it in conclusion.
And that's not uncommon that we have everybody against us too. But yes, we do consider everything. We even consider the one person was against us. Is there something you want to say?
Sorry, I thought we were going down.
We are.
I thought you were actually carrying.
No, go ahead. No.
So of course, I believe that property owners should be able to do with their property, of course, within the township's ordinances. I do think our township has ordinances for a reason. And that's not to say that variances can't be granted. My concern is, I do remember when, our township does have water problems, serious water problems. A man died, 15 years ago or so, in a very bad storm, very serious flooding. And the township responded to that. I live next to a creek, and I've seen what happens when it rains hard. It's a trickle now, and I've seen it go up 4 or 5 feet. And then it goes back down when the rain stops. I was just telling Jim, I now have a beaver, literally right next door. I mean, literally 5 feet. And within the past 48 hours, he has built, or she, you can't tell if it's a male or female, has built a dam. So that's neither here nor there, except for the fact that I see what water can do. And my personal opinion is that the property owner here, or the equitable property owner, is playing with fire, playing with water. In that it is so close. To me, just common sense. I mean, I remember when I had my house removed from the floodplain, a few feet matter in height, right? And a foot or two matters. And right now, the error, margin of error here is so close that it brings me great concern that the neighbors will be affected. Not only the property owner will be affected, or could be affected 5 years down the road. When we build a house for to last at least 80 years, 120 years. That's what we build homes for. And what's going to happen in 5 years? What's going to happen in 10 years? What's going to happen in 20 years? So I have grave concerns over the plans as built.
I have always had an opinion that we should be careful on telling people they can't do something with their lot. To me, I think that's very important. Now, that doesn't mean that I feel that you should be able to do anything with your lot. I don't believe that. But it is the constitutional right to do something with your lot. And if it has to be adjusted to get approval, then that's what needs to be done. That's how I feel. That doesn't mean how I feel about the vote. I'm not revealing that yet, but I do feel that there seems to be, they are close. There's some close things here. I got at the water. I understand what she said. She raised a house and solved the problem, right? So it happens all the time. So maybe that's something that can be dangled about. Maybe that's an issue that can be suggested. I'm a firm believer that you get a property, you should be able to develop it. It's when they bring that up within the limits of everybody else, not just ad hoc, you can do whatever you want. I don't believe that, because I'm sure there's plenty of people along the creek that are not doing what they should be, but that's regardless. But that's how I feel it. And I think it looks like the clients and the appellants, looks like they would be okay with something like that. To me, I'm just saying. But without that, I'd have a problem. And haven't seen anything from either one of these guys that would be agreeable to anything. So they would be agreeable to some kind of an adjustment. So I just wanted to add that in, that I have a strong feeling that, or strong constitutional feeling that you just can't say sorry. And we're going to just say, well, we're going to have the township take over the lot. Really? That's not going to happen. So we should consider, even though you say that, what are they going to do? And I'm sure there's always an instance somewhere around where it's a mess. We got it. And she's not wrong. There is some issues around the township where there's issues with water. But this is just wanted to have some conversation up here so you see where we're at with this. And I don't know, I'm sure everybody's in the audience and people that came in, they're not thinking about that person's particular right. And that's fine. They can think whatever they want. But I do have that feeling that, I have a hard time telling somebody, sorry, you got a lot and it's worthless. Anything you want to add, Matt?
Yeah, we've heard a lot from many people about the floodplain and the wetlands and the stormwater and building on this property, and it all really ties back to the stream. And I agree with Pam on the stream. Water is very powerful, and it can do a whole lot of damage. But I'm also concerned with the fact that the stream has absolutely no protections whatsoever. This stream really isn't even healthy until you get past Ramsey. There's like a section between the Ramsey Loop where it's in people's backyards, but it's generally protected by a lot of plantings, a lot of trees. The stream's generally healthy. Once you get above that, it actually turns into a detention basin in a group of people's backyard, and it goes off into the woods. I think downstream, we've heard from the Lake Association that, you know, the lake is very fragile, and I would agree with that. But I also see as you go down, there's very little protections for that. Everybody there has, well, almost everybody there is basically has grass right up to the edge of the stream. They're taking away all of the protections of that stream. If something goes wrong, grass does not hold well. So I'm torn on this. I would like to see a whole lot more protections for that stream and the wetlands associated with it, but I also know the power of water. So
I would like to add that I believe the opponents, I mean, we did hear some testimony. I think,
Scott.
thank you,
Scott,
Scott, testified that I think you bought your house recently. So, you know, whether or not they're, you know, you kind of buy your property the way you get it, you know, if there's grass there or not. But I think you're right. I think that those homes were built, what, in the 60s?
Yeah.
I think.
this whole area.
And this whole area is being built up.
Yep.
And the water has no place to go.
Yep. And-
Except for people's backyards.
And a lot of those people have
People's
decided
basements.
to take away all of the plantings and the protections for that stream.
Right.
Then I understand what you're saying, but
You got to have.
I know.
We can't, no, we're not, they're just having a discussion.
Discussion.
We're not signing you in and all that.
I got it. If you're not in front of a microphone, it doesn't matter. Yeah. Yeah, that's enough of that. Yeah, really. We have heard plenty of public comment. We do go, that's why we're having this discussion up here right now, which really is unusual for us to do this.
So
We do care about this.
So Anthony, I'm of your mindset. When it comes to land, I have a libertarian point of view on it, that constitutionally people should have the right to develop their land within their rights. And you're talking about making additional accommodations above and beyond what Barbara suggested. I'd just like to hear some ideas on that.
Well, some
I'm
ideas
concerned,
would
I
be-
am concerned about this water resource back there and the ability to mitigate stormwater. Now, as the newbie to this board, we have 2 engineers on it. I mean, Jim's here. Do we have any ideas for water mitigation that we could talk about right now and possibly add into the motion?
What he's suggested is, can something be done to that property where it wouldn't affect the other properties?
I will submit that that was up to the applicant to do, and the applicant did do that. The applicant did have conversations with the township, did have, I think had conversations with the opposition, Mr. Fenningham. So therefore, I will make a motion to deny appeal number 21-1906.
Is there a second?
I'll second that.
Any other discussion? Since no discussion, I'll entertain a vote. You know, I should ask, is there any other motion? Since your written motion is to deny it. Does anybody have a different motion?
Utilizing the township proposed conditions was going to suggest amending those conditions to include additional wetland restoration within the buffer zone and adjacent to the creek to help mitigate overall flows going downstream.
So your motion would be to motion to approve with these conditions plus additional ones.
Correct. And additionally, also including that the conservation easement be signed prior to the issuance of the building permit.
Well, I guess at this point, this is unusual for me. Do we vote on both?
I just want to, well, we don't have a
You
second
got
on
this,
that. I just want to clarify this. The additional wetland restoration by the creek.
Yeah, within the wetland buffer zone to the creek as it's defined here, that it include more than just additional trees. It includes appropriate wetland plantings to the satisfaction or discussion with the township engineer. And then also that the conservation easement be signed prior to the issuance of the building permit.
Would you be open, so the planting is a little vague.
Yeah, I'm open to discussion on.
Would you be open to identifying a density of plant material and a criteria that it be implemented by a landscape architect with?
Yeah, I'm open to your comments on that.
Okay, I would be, if you would add minimum plant density within the stream corridor and wetland buffer of 2 foot by 2 foot for that entire area, I would be open to supporting that.
You okay with that?
I'm okay with that. And I was going to term it as appropriate wetland plantings. So.
So that's your motion. This is uncharted territory for myself. We have two motions here. I had to say.
Is there a,
Can I interrupt?
Sure.
Assume that the density proposal as offered by Mr. Connors, is that something that the township is able to measure? I would ask Mr. Majewski to answer that. Before you go out throwing out values and figures, I want to make sure it's something that's actually measurable.
Yeah, and I guess there's a bunch of different ways to restore a wetland buffer and a stream corridor buffer with a variety of plantings, grasses, trees, and shrubs. The density of 2 foot by 2 foot might sound good, but might not work throughout that area. But I think you're on the right track with saying that appropriate wetland plantings, subject to the review and approval of the township and a landscape architect.
Okay. Because it could be, that could be hedgy where anybody wants to build anything, I'm going to throw in 2 shrubs and call it a day. I want something that's very robust. And if you're comfortable with that, I'll adjust the language, but.
And also just add an appropriate density.
Okay.
What are you talking about, on the edge?
No, that and whole buffer,
The whole buffer.
right? The wetland. If you look at the wetland right now, it's basically grass. Like I'm assuming that you found 2 of the 3 where you have water and hydric soils and the rest of it's grass because it's just been totally obliterated. If we could restore that, it would help with the water. It would slow the stream down. It would actually have the stream work as it's supposed to. I'd also, there's a lot of talk about the floodplain and where the floodplain.
Can I just,
Oh, sure.
what's from stopping the owner from cutting that stuff down
Yeah.
10 years from now?
Get deed restricted.
Yeah, like we do now. We have
That would be
restrictions.
included in the part two, the conservation easement.
That additional suggestion as described would be acceptable to the applicant.
Okay. I like it too.
Jim, I have a question for you. There's a lot of back and forth on the floodplain. Opposition is saying it's not where it is. Proponent is saying it's where it is. Would you be open to requiring a grid for a 50-foot swath over that run at a 10-foot interval, 10-foot grid to really define what that floodplain is so we can get away from the he said, she said?
I was actually thinking of that because I know the opponents have their surveyors say that there's a 0.1 foot error that's in there. And then the applicant's engineer has one elevation, the other one has a 2/10 difference, which if you kind of think about it, it might be right in the middle.
Right.
Given that 0.1 foot margin of error that is typical for that type of equipment. And I think it might be appropriate to get additional information along, elevation information along the rear of the home to confirm the floodplain. And also we would, as part of the building permit process, require that they have the home elevated above that elevation, even if they're not in the floodplain, it would still need to be elevated.
Yep, I understood, but I'm hearing, and I'm very mindful of people downstream not wanting to have floodplain impacted, and I completely agree with them. But I was wondering if there's a way that we could basically kill that he said, she said off, just blow the density up in that area, point density up in that area for the survey, have them submit that plan, signed and sealed as part of the development package so that it is on record and we can require the, elevation points for that building footprint as well. That
makes sense.
Okay. I'm not approving a variance for the floodplain.
Somebody clarify, what's that third condition that was just discussed? How are we going to get additional elevation info? Are you just going to rely on FEMA maps?
Nope. So what I would propose is the survey goes back out and
Which one? Yeah. I mean,
or do we say each of them choose a third?
no, I don't want to get into
No, it
he
has
said,
not-
she said.
time, please.
I would propose that the developer goes out and has a basically every 10 feet in a grid, take an elevation shot. And that would be on both sides of the proposed or where the floodplain line is. It's based on elevation. And that higher point density would allow for a more accurate representation of the floodplain.
Ah,
And it would be for the entire run as it pertains to, I guess, the backyard is where this would be.
so Matt, that would would make it a definitive where the floodplain is.
Yes,
Okay.
that would be my intent.
I think that's good. I mean, I agree with that.
And if it was in the floodplain,
Yeah.
I'm not approving.
Well, they would not, they didn't ask to build in the floodplain, so.
I'm saying if it was in the floodplain, then they would
They
not
would
be
have
able to
to-
comply.
They would
And then
not
they would
be
need
able,
an additional variance.
well, I would suggest that they not come back in for that variance and they would adjust their building footprint.
Agreed. From my side here, I agree with that.
And I'm not trying to be difficult. I'm just trying to understand that the conditions you impose are such conditions that can be clearly enforced.
Yep. I
And
agree.
measured.
I agree.
James, did you want to say something? It looked like you're ready to say something.
I was just getting ready to maybe repeat back what those couple of conditions were.
Oh, okay. But go ahead.
if it makes sense. Besides the ones that the township had recommended, the 4 conditions, 2 additional ones as put forth by Mr. Solar and Mr. Connors. One was provide additional wetland restoration with appropriate wetland plantings to mitigate downstream flooding, use appropriate plant density, subject to the review and approval of the township engineer and a landscape architect. Does that summarize it fairly?
Sounds like it to me.
And then another one was that the condition that the conservation easement be signed prior to the issuance of a building permit. And then the third one, I said 2 before, but it's 3, was to provide additional elevations, the applicant to provide additional elevations on a 10-foot by 10-foot grid in the area of the floodplain to confirm the exact location of the floodplain.
Utilizing a licensed surveyor.
Grid of where the rear dwelling line would be to ensure that the dwelling would not.
What I want is to know where that flood line is.
Right.
And in
Along the
what
rear of
Jim
the
wants,
house, right?
Jim wants to know where that building is.
Right.
Okay. Horizontally as well as vertically.
Yep.
Okay. I know it's been submitted as this, but I want it on the record that the stormwater system will be designed for the 100-year storm.
Sure.
The township wanted a split rail fence, correct?
I believe it was at Mr. Majewski's recommendation that a split rail fence be placed in the buffer area to clearly ID the buffer area to prevent any other type of structures or other impervious encroachment in that area.
One last question regarding that split rail fence. Haven't we sometimes required signage on that fence?
We have.
Have on the fence saying wetland buffer, something like that.
Yep.
So we'll add that to that too.
Do we also in that motion, we're clear that we don't want this in the floodplain, the structure.
The application says it's not a floodplain.
I know it does. I know it does, but yes.
I think Matt's
I'll be very
amendments,
open.
right? I think your amendments say basically they're making the applicant prove
Again,
with additional evidence that it's not in the floodplain.
Mhm.
Is the application by default is not approved, is my understanding.
Or they had to
of
adjust the
Matt's-
building
they would-
envelopes. The
they
building
would-
envelope is no longer.
That's not how I understand it. I understand it is that if it is in a flood zone, then the applicant has to come with a whole new plan and a whole new application.
This is a question for
This
Adam.
isn't
'cause
continued.
it's-
This isn't
I'm-
continued.
I agree. I'm not
Yes.
continuing this. We've,
Right.
but question for Adam. I mean, based on what you heard, I would make the presumption that if they wanted to build in the floodplain, then, and it was determined that they would have to come back in because we are not approving a variance.
Correct. They have not requested a variance to build in a floodplain.
All right. If that line comes in and they choose not to come back in, then they would need to adjust their building footprint in order to be compliant. Is that, am I
They would
understanding that
not be able
correctly?
to build the plans that we, as submitted.
Okay, do they need to come back in if they reduce that building footprint
And get out of the
and
floodplain.
get out and stay out of the floodplain?
Provided that they would not, provided that the modification would not require, additional zoning relief.
Does that work for you? That's what I was thinking, Pam. So I just,
I would like to add to yours because there is a margin of error. So if they come back and do another, do this additional survey with the points that you're talking about. And the margin of error is plus or minus 1/10. I mean, I think it has to be within the margin of error, or outside the margin of error is what I meant. Yeah.
Is 1/10 reasonable outside?
I don't know. I think we're splitting hairs. I think
Oh, there's no
I
doubt.
still am very uncomfortable with playing this so close.
Vote accordingly.
I'm not going to go against that. I don't necessarily believe it, but I'm not going to go against it. So.
Mhm.
You don't want it 2 inches outside of.
I don't.
the
I don't
floodplain.
want it 2 inches. I think water's going to shift 2 inches or could easily shift 2 inches a year. The floodplain could conceivably. So
All right, so where are we then on this? I'm getting confused. Sure. You need your microphone.
I would suggest 3 additional considerations. One is that the 5,000 square foot small project exemption be denied in this context, that you're now evaluating on-site conditions review with a great degree of specificity. So I think
We're
those,
already doing that with that.
yeah, but I think it should be expressly stated that the further evaluation should be not within the looseness of the small project exemption, which we think doesn't apply. Second would be that you require full rate / velocity control calculations, which you don't have and have not been submitted. And third, that the McDonald's be allowed to participate in this post-motion effort presentation review with the building office. Otherwise, we're in limbo and we have a choice of appealing your decision, whatever that may be, or waiting to see what happens. And I've been schooled over the years, 29 in fact, that everything happens at this level. And beyond this level of public participation, an opponent, a party is not invited to the dance, so to speak.
So my
So-
question is exactly what is it that you want them to participate in?
The question is to ask the applicant to submit more presentations to the township and the board, which we will not get the opportunity to review and comment upon. I asked for the opportunity,
Plain elevation information?
talking about whatever further presentation is being invited from the applicant to prove what it didn't prove here. You said you proved it. We say you didn't prove it. So we're
Township, it sounds to me the township engineer is being asked to be the arbiter of our position versus yours. We've been asked to supply additional calculations, as Mr. Connor recommended, to Jim. Jim is going to be the arbiter of whatever.
and we're excluded from that evaluation.
Well, I don't know why you can't participate.
I'm not
All right.
going to give your client the ability to review what he wants to design. I mean, that's like me asking my neighbor if he can approve my addition. That's not,
Well, you
that's
would-
not fair to the applicant.
But you would be granting possibly relief, interim relief, based on what was presented here, which was subject to our review and opposition. And the next step would be to ask for supplemental presentation, which is
May-
not open to review.
From a procedural and legal perspective, I don't know how you would do that. Because if at the end of the day, your appeal period is your appeal period, and all of these things that we're discussing are going to be after the appeal period runs. And then at the end of the day, if you don't agree with it, do you have a veto power? And you've already blown your appeal window. So from a legal procedural perspective, I don't understand how you could ever carry out that request. I understand why you're making the request. And I respect the fact that you are, but I don't know how you would ever do that.
It's real, Adam, it's really intended to be constructive. And I'm just saying this as a conceptual point. If anyone files an appeal, it stays further action. And in my experience is other townships shut the door until the appeal is resolved. And I'm saying, we don't want that to be the case. If we can constructively participate in that process and there's a win-win. I can't forecast because I don't know exactly what you're going to require. But what I'm hearing tonight without further thought is that the applicant gets another bite at the apple and we're out of the picture.
Well, I understand what you're saying, but basically he's saying if whatever Jim wants, if he wants to add that to it, so it's not really that's not uncommon. We make those decisions all the time that make sure that Jim is approving what we said, the other ideas that Matt said and Pete said, and Jim would be looking at that. So why do you need to look at that?
But this is a little bit more complex than
it?
something that is the ordinary run-of-the-mill zoning relief granted, then thereafter complying with all other township ordinances to be reviewed by the building department, and/or further Saldo review, which the public can then participate. So this is a little bit of I submit it's a little bit of a hybrid limbo. I don't know where it would lead me. I'm concerned with Adam that somebody would say, we don't know what's going to happen, so we're going to protect our rights and file an appeal, and that shuts down the process, which I think I'm not trying to shut down that process, but we could be in a position of we have no choice. That's what I'm saying.
But you are trying to shut down the process in that you're opposing the application. And if the board denied it, then the process would be over.
Subject to.
So you can't say that you're not trying to shut it down. That's the reason you're here.
Well, what I'm confused about tonight, quite frankly, is there's two pending motions, which I find very unusual. The first motion was to deny the application. Then we moved away without a vote on that to considering an expansive speaking motion, if you will, which is to be formulated. So even tonight, I don't really know exactly, and maybe you don't. I think it's worthy of your evaluation. I think I'm just speaking from the hip that it requires a collaborative effort to find out exactly what would be the proposed conditions. My clients think that makes sense. That's one scenario. If they don't, that's another scenario. But all I'm saying is I know I have a right to appeal, but I also think that shuts down the process, which I'm not advocating. That's my point. And so the invitation was to participate in that
Can I
process.
say something? Usually when the board makes recommendations to an applicant for certain provisions and say, would you be willing to accept this? Although, to be quite honest, the property owner, nor the equitable property owner, the title record holder, excuse me, and the equitable owner are not present, so we don't know if they will accept these conditions. Oh, okay, so okay, all right. Is what we usually do is the board usually, I mean, granted, this is a complicated appeal. We usually turn to the, the residents opposing it and saying, could you live with these proposals? That's usually what we do.
On certain cases, man.
Right. And so that may be one thing, would your clients, but we have many people who have party status. Would your clients consider
They can,
something like this?
But
and
Pam, we
approve it?
don't know. In other words, the condition is to do a further evaluation and issue a report to Jim. And we don't know what that, yeah, I agree with that. But I want to know what the content of that report is and whether we agree that it's any more credible than what you've seen here that caused you to pause.
So if I may, Mr. Chair, I understand what Mr. Fenningham is saying, but I, on behalf of the township, would oppose the imposition of a condition that is open-ended.
I agree.
That requires the township to consult with Mr. Fenningham and his clients, because one, there's no finality to the issue at hand. And two, if there becomes a time where there's a conflict, how does it get resolved? You're past the zoning matter.
100%
can't
in
have
favor of
that.
that.
Maybe I didn't make myself clear. We're
would-
provided the report and we issue comments to Jim or to the township. And we participate in giving our input. We're not being asked to, Jim's not asking us our opinion. We're getting that report, giving comments, submitting them.
To what,
For what?
what purpose is it to get the report and submit comments?
If there's evaluation involved in determining whether the applicant has presented sufficient data, whether the data is consistent with what the applicant concludes, I heard Mr. Connors say a bright line. If it's in the floodplain, no relief. So based on what I'm presenting
There you
tonight
have
through
it.
my expert, it is, I don't know how they can change the outcome here. It's still going to be this variance of expert opinion. So what I did here, though, was a very definitive grid evaluation, fixing the floodplain with all the criticisms and critiques about how it was done before you. So if we get that definitive report, I'm just asking for the opportunity to see that. But in the darkness of not getting it, I may have to file an appeal.
So if I may, Mr. Fenningham, there's a thing called a right to know law. So if you believe there's a report that's been submitted, you have the right to request it under the
Or
right to know.
I have a 30-day appeal period. You could take 30 days to answer my right to know request.
Essentially, it's almost, I think I'd use this in a zoning setting, but it's essentially like filing an amicus brief, right? You're not a party, but you want to have an opinion on it for.
With all that's
in this
been
case,
involved, we want Jim to have
Jim's
the
office
benefit
and the
of our
township
input.
engineer to review.
We want the township to have the benefit of our input.
So maybe this would be a compromise that any of these submissions, and again, the board can take this or leave it, that any of these submissions would be shared with Mr. Fenningham.
He can do that through right to know.
The only issue with right to know is, you initially have the 5-day period and then they can request additional time. And I don't know how fast this process would or would not move. And
Well,
then you're
not hamstringing you.
potentially out of time if there's been an approval with the township.
Sharing information is one thing with him, that's fine, but we can't have him coming back with another.
The only thing I would say is that you could make a condition that these, the elevation, the 10-foot elevation grid and the buffered plan with plantings could be shared with Mr. Fenningham. That would be the only obligation on
Shared.
I don't
behalf.
think that's
Well,
going to happen
I-
in 30 days.
I was just
I
gonna
was,
say.
I don't think they.
Well,
would
Here,
be able to
here,
do that
no,
within
can I make a
30 days.
suggestion?
The issue would not be, the issue I think that Mr. Fenningham is bringing up is that if he knows he can have access to that, and then kind of like I said, as an amicus, kind of submit any comments that he has to the township, then at least his clients feel as though they are part of that process, even though they have no power explicitly over it, they at least know that their comments will be submitted to and reviewed by the township, whether it's Mr. Majewski or the township engineer. The decision is still the township engineers or Mr. Majewski's. They would just have access to that information without having to go through a FOIA request.
Mr.
I'm sorry, Barb. Another thought is this, based on Matt's comments and Pam's, as far as, in the floodplain or not. What you could do is you could defer and ask the applicant to supplement this record. And so no decision is made, no appeal period begins to run. The supplementation is upon this record in which the parties would have a right to review the presentation. And then you make your motion. And then we're all outside of that issue of sharing or not sharing. Just a thought.
This is my last zoning hearing board.
I'm sorry, Ed.
No
would
one may
oppose that.
care, but it's
we
my
could-
last.
excuse me a
zoning-
second.
I've
We do
resigned.
care,
Different
Pam.
board
You
who has
excuse
to
me a
sat
second?
through The hearings.
Ed, I'm sorry, I didn't hear what you said.
No, I'm echoing what Mr. Fenningham said. I know it's Ms. Van Blank's last.
Oh, okay.
night, and I don't want to have to deal with a different board who hasn't read the transcripts, having to weigh in at a future time on that. So
She's abandoning us.
No, I'm
She has a higher calling.
Elected to higher office.
She's gonna have a beaver collar on her, neck thing on her soon.
almost done with my 6 years.
Oh,
What,
Jesus.
2 months shy?
Little puppy, 6 years.
So I'd like to make a point to Adam, to your suggestion. Nobody's asked Jim how he feels about it. Jim, you're the township engineer. How you feel about working with Mr. McDonald or receiving his input while you're trying to basically underwrite this project?
Actually, I'm not the township engineer, but I work with the township engineer. And I am an engineer, but that's different. But I have no problem with sharing it with the applicant, just as a right to know. If it came in, we would share that with them. And of course, if they saw anything that was out of order, which I wouldn't imagine that our engineers should be able to pick it up, or I would pick up. I don't know that it needs to necessarily be a condition of it. If there's some problem with it, that's something we would work out, just as neighbors sometimes come to us and say, hey, I think something's wrong with this building permit, and we'll maybe look at it. I'm not sure what to do that. I'm not sure if it's,
So working out between him and you and the township, not going.
yeah, I don't have a problem
Sharing the
that with them.
information,
If
but
they-
the working out part would be between you, the engineer, and Ed. Town.
Yeah, I mean, I think we've got both witnesses were very credible with
Oh, without a
what
doubt.
they found, and that difference is just
It's so little, right?
yeah, a couple of inches that I have a feeling might be right down the middle.
Seems like we should
And
be able to
just-
work it out.
Yeah, I think it's something that, done the proper way, I think it'll satisfy everyone. To the extent that they can be satisfied.
All right. What do we do with this double?
I think we need to clarify the second motion.
Do you want to remove your motion?
I will remove my motion or withdraw.
Withdrawal.
And does that clarify the one about the additional elevations?
We have so many amendments that I think we need them.
But Ed has heard them all.
If I may, I've been taking notes unless Mr. Flager wants to do this.
Oh, you've both been writing, but he hadn't heard all the
typed out too.
conditions. Ed and their team has heard all the conditions.
Right.
So what do we need to clarify?
I want to know what I'm voting on.
Oh,
That's
Just
what-
oh, so Jim, you want to, it's probably cleaner than
I
my
will give it
handwriting.
a shot, and you can correct me as appropriate. Condition number 1 from the township was that the wetland buffer area be extended to 50 feet with additional trees being planted as recommended or required by the township, including providing additional wetland restoration with appropriate wetland plantings to mitigate downstream flooding, use appropriate plant densities subject to the review and approval of the township engineer and a landscape architect. Is that right? Number 2, okay.
Because the way he explained it to me, there was an actual distance, and I didn't hear that in there. So if
It was 50 feet.
Oh, I missed that. I apologize. Okay,
No problem.
I'm sorry. I apologize.
Item number 2, the wetland buffer will be further restricted on the record, by the filing of a conservation easement declaration of restrictions, which will prohibit any future construction of any buildings or structures within the buffer area. Said easement will be signed prior to the issuance of a building permit. Okay. Number 3, the wetland buffer area will be set off by a split rail fence, including appropriate signage, so that nothing can encroach into it.
Yes.
And then item number 4, all stormwater roof gutters will be connected to downspouts that are directly connected and flow into the proposed rain garden. The number 5 would be provide additional elevations by a licensed surveyor on a 10-foot by 10-foot grid in the area of the floodplain to confirm that the proposed building will not be within the regulated floodplain.
Yes.
I like that.
Number 6, the design of the stormwater management system for the 100-year storm, subject to the review and approval of the township engineer.
Yes.
And I believe that's it.
And then the only question that was discussed earlier was whether you wanted a buffer outside of the floodplain or not. If you don't, that's fine.
I want it outside of the margin of error.
Okay.
And I think Matt was okay with that, right?
I'm okay with that.
All
So
right.
then that one would just be amended accordingly.
So based on that, has that motion been made?
I guess, Pete, are you going to formally make that motion now?
So moved.
Make a motion to approve Appeal 21-1906 for the 4 listed variances with the proposed conditions as were just read, including that the survey to include the base flood elevation includes the determination, includes the variance for margin of error.
Second.
All those in favor? I'm sorry, any discussion? Oh, sorry. I'm sorry. That's what you mean. If this is, you went
Outside of
outside of this,
normal, I'm opposed to that.
no, no, no.
I don't think we.
And that's, no.
I think informally, though, Jim would provide what
I
is,
have no problem with that, and I think that would be done.
and if informally
That's
Ed wants
fair.
to say that, that's on him, but yeah.
All right. We had a second. We've had plenty of discussion. All those in favor of the motion, say aye.
Aye.
Aye. All those opposed?
Aye.
That's one, James. 4-1, motion carries.
Thank you for your.
Did you vote?
I didn't.
Oh, what are you gonna do? It's your last,
I didn't hear you.
I wasn't.
Go ahead, say it.
Oh, I'm having such a hard time with this one.
That's because you're leaving us.
Trust me.
No, this is just really hard one. So my gut is telling me no, so I'm going to vote no.
So what is it, what do we got here?
3-2.
3-2. 3-2, motion's approved. There you go. I want to thank you guys again. It was an incredible experience. And I hope everything works out. I think it will. I really do. Thank you. And public, the guys in the public, thank you very much.
I want to thank Pam for her years of dedicated service, and I wish you the best serving the
been my
residents of
honor.
Bucks County.
Thank you. I
Thank you
appreciate
again,
it.
Pam.
I just want to say you're a quitter.
This was the hardest.
Pam, you want to make
So
that
moved.
as your last motion?
So moved.
All right. All those in favor, say aye.
Aye.
Aye.